benefit of hindsight, and we know what you know about the Petroleum Act now, and you know what his answer to you then was, do you think that you would have won?
I wouldn't. You see, that's the funny thing. Up to the day I challenged him, I took about 7 of my young lawyers to his Abeokuta residence. And I was telling him, Mr. President, my late friend Sally Jambo asked me not to take you to court. He said, look, Bob, if you had gone to court, you would have lost. He now sat me down with all my years of experience and made me to understand that if I had gone to court, I would. And I realized that. I realized it.
Okay. Give us your perspective on this Supreme Court matter and Bode George, because I think it was on Sunday where Mr. Falana, SAN, released this comment saying that the Supreme Court was wrong in quashing the conviction of Chief Bode George.
You see, with the greatest respect to my brother Falana and also Professor Sage, I think Professor Sage anchored, the same opinion as Falana. But I believe that they have done it in the wrong way.
Why?
You see, under the Constitution, the Supreme Court, as the apex court in Nigeria, is the final court of arbitration in any matter. The only appeal you can take is to take it to God. But within the system, the Constitution says, look, when the Supreme Court decides on a matter, you can still go back to that court and ask for that matter to be reviewed.
So the Supreme Court can reverse itself?
And now let me explain it to you. A review is not an appeal. The system says, or the Constitution says, that if that error you have discovered in the judgment is going to lead to a miscarriage of justice, then you can sit us down, we will look at it. Let me give you a clear example. I am not saying this for any ego. Last year, I challenged a judgment of the Supreme Court in a case in which my client was involved with the central bank. I wrote a petition.
So the Supreme Court can be challenged?
Oh yes, I did it last year, and that's what I'm trying to say. I now challenged that judgment, and I asked it to be reviewed. At first, and you have to give credit to the present Chief Justice of Nigeria, when I wrote to her, she replied that under Section 294 subsection 5, we cannot review it. Despite and in spite of her letter to me, I decided to file the application for a review. Seeing what I have stated down against that judgment, she quickly set up a panel. And that's why I say you have to give her that credit. She set up a 5-man panel, and I had to address the Supreme Court again, even though I lost. But they gave me that opportunity. What I'm now saying is that Falana and Sagi, they are aware of these provisions. Because when you start politicizing judgments of the Supreme Court, the way and manner is being done, it is not fair, because these people cannot reply. When you have within the system an avenue to ask them, look, why should you declare Section 104 and Section 203 of the laws of criminal laws of Lagos State illegal without listening to the Attorney General doing this? Why not go back and bring an application for that judgment to be reviewed so that your grounds about that particular annulment of those 2 sections can be heard? Because the only time the Supreme Court can reverse itself is when a similar case comes, and then they review their position in the. Let me give you a clear example. We have what we call conflict of judgments of the Supreme Court. Supreme Court on a point of law might decide, and tomorrow they decide it another way. There is a particular case I took up 2 years ago in the Supreme Court also, where justices of the Court of Appeal, a particular, panel, refused to follow the latest judgment of the Supreme Court and decided to follow an earlier judgment of the Supreme Court, which was in conflict with the latest judgment. I now went to the Supreme Court and I decided to say, look, what does it matter if you don't want to review a judgment. The point now is this. The Supreme Court now says that if we have an earlier judgment which now contradicts our present judgment, it should not be regarded as a conflict if our attention is drawn to that judgment. So that area has been settled. So I will have urged Falana and Sagi, instead of politicizing a political case, because Body Judge's case is political, no matter what angle you want to look at it, they are now politicizing it. It's not doing, good for the credibility of the Supreme Court. I'm not defending the judges of the Supreme Court here, but what I'm saying is that they have no right of reply to all this criticism, and nobody is going to help them to say, oh, this is why we did this. So, to help the judicial system in this country, Falana and Sagi should have gone back to the Supreme Court, bring an application for it to review that aspect of its judgment, and they will gladly do it.
So first they had that option, and even if they had taken that option and it still didn't go the way they wanted, could they have made, or could they still be able to make a comment or two saying, look, well...
You can make comments about judgments, don't get me wrong. You can write articles criticizing judgments of the Supreme Court. I have done it. 10 years ago, there was a judgment by the Court of Appeal in Lagos convicting certain Air Force officers under the court-martial system. And, I criticized, the Supreme Court reversed that judgment, and I criticized the judgment of the Supreme Court in the newspaper. That is constructive criticism. But when you now make comments, to say, oh, the Supreme Court was wrong to have done this, without following it up legally, then you are not playing to the rules.
So what you want them to do is also not just make comments, but follow it up legally as well. Is that what you're asking them to do?
What I'm saying is this. The judges of the Supreme Court have no opportunity to reply. These statements have been made on a political case. Forget that it's a criminal case. But the judge's case is political. It has political following. It's just like Al Mustafa's case. No matter what you say, it's a political case. Now, what I'm saying is that Falana and Sagi could have taken this matter up in a legal manner by asking the Supreme Court to review that judgment, especially that area of Section 104 and 204.
What if laymen were the ones to criticize? Because some people have, come up with the stance saying that it's not right to criticize a Supreme Court judgment. The Supreme Court is the Supreme Court. But others have argued that the Supreme Court is not infallible, that they can make mistakes, and it's so unfortunate that that's where it stops after them. It's God.
You see, in all civilized countries,
yes,
that follow the same system of judicial system we have, in America, in India, in Australia, they allow reviews of their apex court judgment. And I mentioned this in the brief I wrote when challenging, a judgment, that it is not an uncommon thing. In Great Britain today, there are 10, 15 cases of judicial review of apex court judgment. In Australia, so it's not new. It's only in Nigeria we prefer to go to the newspaper and, challenge things when the other party cannot reply. My own contention is this. You are bringing judges of the Supreme Court into the arena of public opinion when they cannot reply. Whereas you have an alternative. Mm-hmm. You can still get the political aspect of that by even going to court to ask them, oh, I am not happy with your pronouncement on Section 104 and 203. I want you to review it. They could have still got the same political whatever it is through the legal manner.
The question would also be what you make of their comments. I mean, aside the fact that you quarrel with them that they didn't ask for a review or not taking it through the legal channel, do you have quarrel with the content of their criticism?
You see, the law, nobody is the custodian of law. the way they see a legal point may be different from the way I see a legal point. I am not going to challenge a judgment if I have not read it. I have not read what the judges. What I'm just saying is that that aspect of that judgment, which they now start to criticize, they should have done it in a better way than the way they are doing it.
Well, anyway, before we leave this issue, I wanted us to talk about the legality of these defections we saw last year. You were in the First Republic, you were in the Parliament then as a young Nigerian. Then that was when we talked about crossing the carpet. And I doubt if we can also use that now, so perhaps let's use the word defection.
You see, in Nigeria today, the constitution is very clear. Only the executives, that is the governor or the president, can move from one political party to the other during the tenure of his office. But for legislators, if they move from one to the other, they lose their seats. But the question is this: the law allows that if there is a division within a political party, if there is a division, then a member can move from one to the other. But the question is, who determines whether there is a division? It's a question of law and fact. Now PDP says we don't have a division, and that's their contention, and they want to go to court. But the other people will say, yes, you are entitled to your own opinion. There is a division because the new PDP has already, emerged from your old PDP.
Even though the INEC also said, look, we know nothing.
They are not asking for registration with INEC.
Yeah, but
they are not creating a new political party.
What about the court decision that there's no such thing as a new PDP?
No, they didn't say that. The court, because I am one of the lawyers representing the new PDP, that the court has not said that it's not enough.
Did they recognize them as a new PDP?
The issue that went before the court, in which I participated in Abuja, is not for recognition. What we are saying, or what our clients were saying, is that, look, there is a division. We held a parallel, conference, when the other party too was holding its own, conference. So it is still the same party, PDP.
Even though they say, look, there are procedures to holding that parallel conference. So if you have not fulfilled those conditions preceding that conference, you cannot be said to have held the conference.
They can go and settle that. That's why I say it's a question of fact and law. What constitutes a division depends on the facts. As I said, there were parallel conventions. It's the court to decide which is the authentic. I use the word authentic because I remember the First Republic or Second Republic when Azikwe's party, there was a division, and Senator Anna called himself authentic, so it's the court that will decide that.
Okay, looks like it's going to be very interesting when they eventually get back to this matter, especially as we're looking forward to the National Assembly resuming their activities. Who knows what will happen in that house? We want to thank you for coming on, Robert Clarke, a senior advocate of Nigeria. All right.